My lord, putting some final pieces of the jigsaw in place.
Yes.
The judgment itself is the core bundle, page 83, paragraph 12. I'm referring to this just because it's convenient to identify further aspects of the structure which are set out here. So paragraph 12, the Windrush Scheme document explains how applications will be considered. Application of the Windrush Scheme will be considered under existing law and policy as this document will be applied. Then the Windrush Help Team will not consider any application which falls outside the scope of the Windrush Scheme as set out in this document. So that is indicating then that that team will look at applications which fall within the Windrush Scheme. In paragraph 13, the additional document which we sent over yesterday, the Windrush Scheme casework guidance, and that specifically states that the policy does not provide for consideration of any application not made on the Windrush Scheme application form or consideration of another application type that is made on a Windrush form. However, the task force may direct a person to the guidance on how to make other applications for leave to enter or remain under the existing immigration rules. And of course, we would say one can read into that and outside of the immigration rules.
That emphasises the point that you were making just before lunch, which is, in answer to the question that I posed to you, is that the approach that's mandated is if somebody does not, in the opinion of the caseworker, meet the requirements, then they have to go back.
Yes.
And this reinforces that because it's on the face of the policy.
It does, and one sees that in the letter, and I will come back to it at page 200 and indeed at 198. But just before the documents, is any of that inconsistent with the British Oxygen principle? Well, see please Lord Justice Leggett in AB, authorities, tab 16. Page 569. I refer to this simply as a more recent restatement of well-established principles. Paragraph 44. Public authority which has a discretionary power may adopt a policy or rule to regulate the exercise of the power. And indeed, if it fails to act consistently with its rule or policy, the decision may be open to public law challenge by a person adversely affected. At the same time, the principle against fettering discretion requires decision makers not to shut their ears to claims falling outside the policies they've adopted. And the explanation is given as to how that operated in the context of British Oxygen itself. So broadly speaking, the principle is not to shut one's ears. And we say, well, that's absolutely right, well understood. And that is why there is a structure in place to ensure that the ears are open.
Yes, I think you say there has to be a channel of communication to that ear.
Yes.
But the individual is not entitled to decide what that channel shall be.
Yes.
And the government is entitled.
Indeed.
Specify what the channel should be.
Indeed, my lord. And
I think you also say that if it happens that one or more channels which are so prescribed entail the payment of a fee, well, as long as there is some legal power to impose that fee in the first place, then again that doesn't offend the British Oxygen principle.
Indeed. So take, for example, British Oxygen itself. What if the entitlement to access the grant, the primary obligation, required a payment of £500, and the discretion outside the policy also required £500? What would be the objection? The fundamental right that has to be accessible, whether that's accessed through the scheme or through the discretion, fundamentally doesn't make a difference, and it therefore is logical. If there are fees, they apply whatever the route.
Yeah, and here, as it happens, although the Secretary of State has power to impose a fee, she chose not to do so in respect of the Windrush Scheme.
Yes.
But your answer to that point is, well, if a case does not fall within the four corners of the Windrush Scheme, it is by definition outside the scheme for which there is no fee.
Yep. That's how we put it, my lord.
Right.
Yep. Then, just in terms of how this then manifests itself in terms of the application, so that the 20th of April 2023 letter, which the court has already looked at page 200 of the core bundle, perhaps if I could just take it from 198. Bear in mind that the context of this, for what it is worth, it is not simply an individual application by somebody with no familiarity. This letter is sent by experienced solicitors, lead A as it happens. And the information that is provided, and at 198 there is the section what this means for you, and it provides specifically information as to those other routes. And it's all publicly available information anyway, so it is available to the general public and is specifically known to experienced solicitors such as lead A. And that is repeated in the passage which my lady explored with the appellant earlier, which is at the bottom of page 200. You're reminded, as detailed above, that there are other immigration and nationality routes by which you may be successful in gaining status in the UK. This decision only relates to the fact that you're not eligible for that status via the Windrush Scheme. Is any of this contrary to the Alvey principle, i.e. that rules need to be set out and subject to the negative resolution in Parliament? The answer to that is no. What one has here is effectively a set of rules and then two different bases on which the residual discretion will be exercised. One which is narrow, which is the Windrush Scheme, and one which is wide, which is the general Lotter approach. That is, we say, apt then to cover very much substantially the range of situations in which the Secretary of State will in fact exercise discretion, subject to my Lord's point that there may always be a yet further exceptional case. And the appellant's application itself, the court's seen this, it's in the supplemental bundle at page 130. And one can see how the issue arises. So 22-page letter, pre-action protocol letter from lead A. So directed, goes to Government Legal Department. The claimant sets out in terms then that it, so paragraph 5, its refusal to grant indefinite leave to remain under the Windrush Scheme. In paragraph 6, for the reasons set out below, the claimant should now be granted indefinite leave to remain under the Windrush Scheme. And the only reason I identify that is that it tends to explain why the response is phrased in the way that it is. Now, I'm not seeking to suggest here that the letter doesn't go on to refer to the point about discretion. It plainly does. So what is set out then is all the details about the family members, all of the relevant facts, which are said to justify the exercise of discretion. Paragraph 21 deals with the Windrush application.
One might have thought, Mr Brown, if the short answer, as perceived by the government at the time, was we can't exercise any discretion outside the rules because you haven't applied on the right form, that the person who was writing this letter would have said so.
Yes, so I accept that this could have been improved, and inevitably when one is in the Court of Appeal, it's because something could have been done a bit differently.
Yes.
That's precisely right. If this had been drafted with the benefit of all the learning that we have now, the point would have been made clearer. It clearly hasn't been. That's why the judge puts it as, the issue requires a close examination of the correspondence between the claimant's representatives and the government legal department, because there's a sense of ships passing in the night, because the claimant is saying, well, it's the Windrush Scheme and a failure to exercise discretion, and individuals within the Windrush task force saying, well, you don't meet the scheme, therefore we've got some difficulty with this concept. Now, lead A, we would say, should be taken as knowing then of this additional power, additional right, and is clearly open to the claimant, whether or not with the benefit of specialist legal advice, to do what the letter said, the original 2023 letter, and simply identify the information online and make that request on that form. The real substance to all of this appears to circle back to the points that we were canvassing before the short adjournment, which is that, well, if one goes down that route, one potentially is in a disadvantageous position, i.e. potentially being required to pay a fee and potentially receiving an outcome which is perceived to be not as advantageous. Now, all of that's not said in terms, but were it not for those two factors, then it's very difficult to understand why we would be here. What would be the problem with the claimant doing what the Secretary of State says is the right course, which is to apply under the general policy. So the letter then sets out from paragraph 30 through to 32 all of the relevant aspects of the Windrush Scheme and rules, and then 32, the power of discretion. It is indeed trite law that the defendant has very wide discretionary powers.
Look, which page are you on?
So, my lord, paragraph 32, please, on page 142, supplemental bundle. Uncontroversial statement of principle.
Thank you.
And 35, the contention is unlawful refusal of ILR under the Windrush Scheme. And various reasons are advanced in relation to that. And the point about discretionary powers is then revisited again at 43. And simply a statement then that there's wide discretionary powers. So this letter doesn't engage with the point that's been made, namely that there are other routes available.
Well, I think that from the perspective of the letter writer, it's
Yeah.
being characterised as a refusal to exercise a discretion to waive one of the requirements of the scheme. That's the way that it's being looked at from
Yeah.
that prism.
Yes.
Whereas from the government's perspective, it's not a question of waiving one of the requirements. The requirements are there.
Yeah.
If you don't meet the requirements, there are other routes that are available.
Yes, indeed.
So it's not a question of exercising any discretion to waive something at all.
Yeah. That's why there is basically a mismatch
Yeah.
in the correspondence. And I agree with that, my lady. So the claimant is expressing it in a particular way and the government is responding in a slightly different way. Which is why it's a slightly tortured argument about what the meaning of the phrase discretion was not considered to be appropriate in fact means.
Yeah.
And hence why the judge at paragraph 30 felt that the issue required there to be this close examination. And we do make a wider point that that is in itself highly problematic and a very powerful reason for allowing the Secretary of State to put in place what is actually a very clear and comprehensive alternative process, which is that you simply identify the visa application form and you make it. You make the application on that basis and it will be considered. Clearly that is better than this process, and indeed what would sit behind this process if it were permissible for any person to invoke the Windrush Scheme as a means to accessing ILR or something else, even when they didn't qualify. effectively there would be what we did describe in the skeleton argument as carte blanche, but that would be the outcome. You're basically saying, well, claimant will just decide to go through the fee-free Windrush Scheme route, whatever their circumstances. And they'll seek to access the legal entitlement to discretion that way, and there's nothing the Secretary of State can do about it. So we say then, on the respondent's notice, primary point, it's entirely correct and consistent with what was said contemporaneously, that the correct application has not yet been made. If it is made, it will be considered, and therefore the appeal forced to be dismissed on that additional basis. The subsidiary respondent's notice point is in relation to the words discretion was not considered appropriate. Now, taken on its own as a matter of language, I would accept that probably bears the meaning indicated by the claimant, namely that, well, there was no discretionary consideration in this case. But the fact of the matter is that there was consideration, and that's set out in the material that's in the application. Because what that evidence indicates, which the court has considered de bene esse, so unagreed bundle, page 4, is that in 2021, the head of Windrush Scheme policy has specifically considered the circumstances of the individual case and considered whether it be appropriate for the Secretary of State of her own volition to act in the same way that she did in relation to the brothers. So as a matter of fact, we say it is clear that there has been a consideration on what is on any view a discretionary basis, and that is likely then to have informed what the letter writer meant with the words discretion was not considered appropriate. And true it is, they have expressed themselves in a way that gives rise to ambiguity, and the judge has considered it to be ambiguous. He's considered that there is two ways of reading this sentence, but preferred one. And we say, well, the actual evidence demonstrates that there has been consideration, and there's no reason in principle why that cannot be brought into account when considering, in fact, whether there has been the exercise of discretion, which is the real question here. It's not so much what the letter says on its injective interpretation. The real issue is whether there has been a discretionary evaluation of the claimant's case, and the answer to that is that there has.
Well, in 2023 or in 2021?
2021.
Well, why is that relevant to this case? Because this is about a decision made in 2023.
Because the fact, well, the relevant circumstances are fundamentally those that are considered in this email. So there's no obligation to keep on doing it. There has been consideration of the facts of the individual case and whether those facts taken in the round justify discretionary consideration. And that is what has happened here. Now, if there was some particular striking point which then requires that discretion to be taken again for the second time, then the case would be a different one. Fundamentally, it's precisely the same points. It's the immigration history of the individual which are comprehensively evaluated and subject then to a general discretionary consideration. And that includes all of the points that are relied upon by the claimant.
There's not much consideration in here about the circumstances of her children or the position of the child who has special needs, is there?
Well, that's because here this is a Windrush decision maker considering the matter by reference to what the claimant would say is the spirit of the Windrush policy. So if we're back on the claimant's territory and in fact there is a discretion which arises under the Windrush scheme, then it's precisely those arguments which this decision maker has considered. The points that my lady makes would be apt for a general application on an Appendix FM form.
Was there a witness statement filed for the Home Office in line
Yes, so there's the first statement of
Same lady.
Yeah.
Bertels's Mall. It's the same witness. Yeah.
yes. Yes, it's the same witness as the witness who supplied the fresh evidence. So it's not Mr Shotness who's the author of the email which I've shown the court.
No.
So there is.
But did the author of the letter in 2023, which is the decision under challenge, did these judicial review proceedings, did they give evidence to the High Court saying what their decision-making process was?
No. No, so
You're inviting us to put together two different pieces of evidence and infer that the author of the letter in 2023 must have had in mind what somebody had been saying back in 2021.
no, my lord, I wouldn't put it that way,
No.
because I can see the difficulties with that. And, the first point is we would say, well, when my lord says there should be a witness statement, that all depends on the circumstances. If in fact the alternative material was cogently set out in evidence, then there would be no need for a witness statement.
Yes.
So I accept that a witness statement is likely to be the best course. What I'm asking the court to do here is to consider what the Secretary of State's view would have been. What would have been the decision? Now, my lord's putting to be a situation where it's possibly going to different decision makers at different times, but that doesn't make any difference because fundamentally one can, or the court can, if it feels it appropriate, make a decision as to what the Secretary of State generally would have done by reference to those two sources of evidence. There's no reason in principle for that.
Forgive me, Mr. Brown. Conceptually, we haven't reached section 31 yet. This is the respondent's notice.
Yes.
As you put it, your subsidiary respondent's notice point, which is that the judge was wrong to conclude that there had been no, that there had been a fettering of discretion in,
Yes.
in 2023.
Yes.
That's a factual question.
Yes.
It's not what would have happened.
Yep.
And on that question, I'm still having difficulty, I'm afraid, seeing what the relevance is of what somebody said back in 2021 in order to understand what happened in 2023.
Well, my submission on that point is as follows. When the 2023 decision maker uses the words discretion was not considered appropriate,
Yes.
The court should consider that in light of the fact that the decision maker is assumed to be familiar with the case and therefore knows that in fact that there has been consideration. I put it no higher than that.
That's hard to accept when the existence of these emails wasn't discovered until after the hearing before the judge.
Discovered by
You
the
would think the decision maker in 2023, if they were considering what had happened in 2021, would have it all part of the same clip.
They weren't discovered by the litigation team. So they were obviously known to the relevant individuals. And indeed, what the witness says in her second witness statement.
How do we know that?
Well, the witness says in her second witness statement, explaining why they're being provided now, is that they were sent to her when the judgment was handed down. So they exist in the clip of documents, but they were not provided to the litigation, those handling the litigation, for the reasons set out in the evidence. So there's no reason to think that the case would not have been based upon the relevant material, because the decision maker, assuming a reasonable level of professionalism and competence, would look at the history of the case and make the decision on the back of it. That, respectfully, we would say is it must be a relatively safe assumption, absent some indication that that is not the process that will be followed. Otherwise, how is a trained decision maker going to respond to a legal letter of this nature? They'll simply look into it and see. So we say that that tends to suggest, because it is assuming it's factually proven that discretion has been exercised, and I suppose the only issue is, my Lord's point, well, is there a sufficient causal link to the decision that one can then safely assume that the word discretion is not considered appropriate to referring back to it? And I don't have any further material, but it's simply a submission based on how one would expect the ordinary processes of a government department to work, namely that there would be an evaluation of the material and an explanation provided.
The real difficulty I have with all of that is the word "as." I mean, if you just read it on the face of it, it doesn't. We we're not exercising a discretion because of mandatory requirements. Now, in the light of the first respondent's notice point, that makes complete sense to me, because knowing what we now know, I could well see a decision maker saying, right, you don't meet the mandatory requirements, therefore we're not into the realms of discretion. You've got to, and what they should have said is, you've got to tick the right box. You've got to go through the form. So from that point of view, it makes complete sense. But it doesn't make a lot of sense with respect to say, well, discretion was considered appropriate, not inappropriate, because somebody else had decided whether or not the Secretary of State should have exercised a discretion of her own volition 2 years earlier, and because it wasn't considered that it was sufficiently parallel with cases in which the requirements are met, we would not deal with it. I mean, I think the language of this letter would have been completely different if that's the exercise that had been carried out.
It may be, and I don't seek to improve on the letter, and I appreciate that the letter writer has not provided a written statement. My lady may be right. That may have been the way that an ordinary person would have expressed themselves. There's a degree of ambiguity which the judge recognised. The fact that it's 2 years earlier, in my submission, is unlikely to be of great significance. There's a relatively small population of complex cases, and many of them have been litigated, but the complex cases will generally be considered by the people who are responsible for exercising these sorts of decisions. So all I can say is it is likely that the issues in question will have been known because they have been considered in the specific case by the head of the Windrush task force, and it is the nature of the scheme, and that's simply as high as I can put it. We're not here concerned with general applications that are coming in, family reunion applications where there's very large numbers, very different sets of facts. Here, it's a fairly small population of complex cases. If that is, in fact, the reading, then I accept that this probably turns more into a Section 31(2)(a) submission, namely that one now does, in fact, have sufficient primary evidence of what the discretion would, in fact, have meant, or how the discretion would have been exercised from by the relevant Windrush individual acting on behalf of the Secretary of State. And that, for these purposes, is sufficient. Simply has to be highly likely. Power does allow one to carry out a degree of prediction. It's not an absolute binary test. It is an evaluation of what the material shows, and in circumstances where the specialist decision maker, indeed the most senior specialist decision maker, personally considered the matter and provided a reasoned explanation for it, there's no reason to think that that would not in fact represent the settled view of the Windrush team on behalf of the Secretary of State. That's all I propose then to say on the respondent's notice, and that largely covers the points on the appellant's notice as well. So broadly speaking then, appellant's notice point, certainly as originally formulated in writing, is on the basis that if one has strong and subsisting ties to the United Kingdom, one can rely on that to come within the terms of the Windrush scheme or an exception to that scheme specifically. And we set out in writing why we have some concern about that general approach, because it does do precisely what is identified as a concern in the Lotter policy, which is set up effectively a parallel type route. And bear in mind that these are complex policy judgments which have been scrutinised by Parliament as to who will benefit from this particular extra statutory scheme and who will not. There will inevitably be cases which are close to the line. in terms then of the judge's approach to the section 3128 issue, if I can ask then the court to return to the judgment. And it is perhaps slightly difficult to extract the reasoning from the points which have now been ventilated in terms of the respondent's notice. Picking up the paragraph 51, so judge identifies at 52 no witness statement, however there is material from which inferences can be drawn, and that in itself is not contrary to authority. That is fine, may not be necessarily desirable in many cases, but if the inference can be drawn, then that's evidence in the same way as a witness statement. The question is really, is that actually sufficient to meet the section 3128 test?
And do you accept that there has to be evidence, but you don't accept it has to be in the form of a witness statement?
Yes, there has to. Yes, plainly there's no substantive difference between inferential secondary evidence. It is still evidence that may be more powerful than a witness statement, which itself is perhaps poorly reasoned, for example. So it all depends on the quality of the evidence as opposed to the form. So if there's a strong inference, that may well be sufficient in an appropriate case. And here then, the point that I made submissions on, namely that there is a degree of ships crossing in the night, the Secretary of State is responding to slightly different arguments, but in substance, we say the Secretary of State has dealt with the points and one has to effectively examine this in two ways. If I'm right about the respondent's notice, then we say it doesn't actually arise anyway. But I suppose there may be a permutation in which I'm right about the respondent's notice, but it's still possible for the claimant, in this case, to say the discretion falls to be exercised. Not entirely clear if that's how the claimant would put it. But here then, the issue is, well, what's the evidence which tends to suggest that the Secretary of State has considered all of the points that are being raised by the claimant contemporaneously? And the judge goes through the points that are being made, namely the enforcement action, the historical injustice, and then strong ties in section 55. First two essentially not pursued. Then the compelling, compassionate circumstances in her case. On what basis would a Windrush Scheme application have resulted in a positive decision by reference to those factors? So the ADHD in the section 55 point, because the Windrush Scheme says nothing about that. It's not intended to or designed to confront those sorts of compassionate factors at all. So if the logic of this point of the argument is, well, I'm only going to apply through the Windrush Scheme, but I'm going to make points which are effectively non-Windrush points, then would no doubt dispute that. But
there's nothing in this passage to address the main point, which is the strength of the ties to the UK, which is what the judge himself recognises that particular requirement is a proxy for.
Yes, but the prox, assuming that the court accepts, for the sake of this argument, the submission that the proxy argument is problematic because, in a sense, all immigration rules are about connections to the United Kingdom. That is what they're all looking to do, because Parliament is only going to confer British entitlements and rights for people with a sufficient connection to the United Kingdom, in the main. Then that's really not telling you anything at all, the strong connections to the United Kingdom, because otherwise there's simply no point making any form of application. You've got to have some reason to ask the United Kingdom to provide you with relevant assistance or status. So you have to inevitably have a connection to the United Kingdom in every case, or at least nearly every case.
Well, of course you have to have a connection, but the judge makes the point that the requirement for residence or for continuous residence is to demonstrate the strength of those ties.
Yeah.
And if you can demonstrate the strength of those ties in some other way, then the argument that was being put to the Secretary of State, rightly or wrongly, is, well, I can't say I was here for 5 years continuously or however long it was. I haven't been here continuously since the cut-off date. But I can show a commitment by other evidence. And that is enough to, on the claim, looking at it through the claimant's prism, give rise to a justification for waiver of one of the requirements of the scheme. Now, I accept that the judge is looking at it through that prism rather than the prism that you say is the correct prism. But looking at it through that prism, speaking for myself, I can't see anything in this passage that addresses that point.
But one has to marry together what the claimant says, as set out in paragraph 53, and what was being said at the time in response. So what the judge does correctly is to identify what the 4 points are, because this isn't at large, this is looking at what's actually been said by the claimant. There are 4 points, and the judge systematically explains either that they've been dealt with at the time, or they just don't have any sensible connection to the Windrush Scheme. That's the gist of what the judge is effectively reasoning. So paragraph 1 says rejected in the letter dated 25th of May 2023. So if that's right, then it's being considered and you've got reliable reasons to go on. Then 2, paragraph 60, the historic injustice point, again dealt with contemporaneously. Then 3 and 4, in fact how it's brought is that the claimant has strong ties to the UK and there are compelling compassionate circumstances in her case, which include her son's diagnosis of ADHD.
Well, let's assume that the judge is right and says, well, those don't actually come into play on a Windrush point. Where do you say he deals with the strong ties point?
Well, so paragraph 63, his reasoning is that with respect to points 3 and 4, they're not specifically addressed in the letter of 25th of May 2023 for reasons that I've addressed the court on. If they've been considered in the exercise of discretion, they wouldn't have arisen under the Windrush Scheme. They would have been considered under the more appropriate route. And that's plainly right, because 3 and 4, 3 has a very tenuous connection to Windrush, but it's in fact substantially about the compassionate circumstances arising from a family member. And 4 is just about section 55. So the judge, because he is an experienced public law judge in this field, understands that those are points which are in fact proper to the general discretionary consideration. But that application was never made, and if they were, then the judge is effectively being forced to do what the claimant requires him to do, which is, well, consider it by reference to the Windrush criteria, which say nothing about that, because they're not designed to. The relevant criteria which deal with those factors is, broadly speaking, the policy which I've been addressing the court on. So you're really just left with 2 words, which is strong ties, and we say, well, that is just far too vague, because the word strong ties to the United Kingdom is effectively inherent in every single application that's made.
But the judge here had the granular evidence about this individual, whether or not she had strong ties. But he doesn't consider that. He just says, well, strong ties is a general exercise of discretion, not an exception to the Windrush Scheme. This was a Windrush case, so the discretion shouldn't consider those general points.
Yes, well, we would say that it must be right, and the judge should be taken as known, that strong ties or strong and subsisting ties is putting the matter at such a high level of generality that it becomes meaningless, because one can't bring in an immigration application and say, I have got strong ties.
But the basis of your submissions, which I think I understand, and the judge's approach, is that he was not thinking, well, she doesn't come within the Windrush Scheme, the Secretary of State indicated that she would consider it under the more general discretion, under the exercise of her discretion. But that discretion was to be exercised in the limited context of being an exception to the Windrush Scheme.
Yeah.
Whereas it might be argued that once the individual falls out of the Windrush Scheme, if the Secretary of State is looking at her wide unfettered discretion, that's the moment to look at all the factors, whether they're Windrush connected or connected to ADHD or life in general. But the judge didn't do that. He limited it to a Windrush exercise and said, I'm not concerned with those general things. If they're a point, she can apply under FN. Is that right? Yeah.
Yes, I entirely agree. That's precisely how he...
You say that's right, in fact. You would say that's right.
And that's what you're submitting.
Because the section 31(2)(a) consideration in relation to the wider discretion doesn't arise because there's not been an application for the wider.
What I am formally saying is that the section 31(2)(a) outcome is the correct one. Now, as to whether that requires me to defend every aspect of the judge's reasoning, I would say it does not. The judge has heard argument on a slightly different footing. But the appeal is against the order, not the reasons. And we say that the outcome, albeit that the journey is a slightly different one, the outcome is correct. And it's unsurprising that the judge approaches this by reference purely to the Windrush Scheme, given the strong submissions of the claimant. But that then comes up against the problem that, absent the issue about historical injustice, there's actually very little Windrush element to it. And that's what the judge is identifying in his analysis. So this isn't anything that the Windrush Task Force is likely to think justifies discretion. And in fact, that was the factual position as it happens.
Mr Brown, can I ask you this? Analytically, is this argument freestanding, or does it depend on your first respondent's notice? Are the two connected? Like, I can understand what you've just been submitting, if you're right on the first respondent's notice point. But the appeal was launched on a different footing because of the way it was argued in the High Court by the Secretary of State. And so, assume you're wrong about your respondent's notice.
Yes.
Then can you defend what the judge has done under section 31(2)(a)?
Yes, because the outcome remains the correct one, which is that if in fact the law requires there to be a Windrush-centric discretionary approach, so one ignores the wider discretion and then looks at it through the context of Windrush only, the two actual, we would say, significant Windrush points are addressed. That's Roman 1 and Roman 2. They're addressed contemporaneously, and that is sufficient for section 31(2)(a) purposes. The predictive approach is really Romans 3 and 4. And what the judge in substance is saying is that there is nothing here which is in fact a Windrush feature as such. Because if one removes the historic injustice from the equation, and one simply looks at this by reference to section 55, the family links, and of course a connection to the United Kingdom, but knowing that everybody who applies is likely to have a connection to the United Kingdom, then those points simply cannot pass muster, and there's no view on which they could. And the judge is clearly entitled to reach that view when one considers that the real Windrush points didn't impress the decision maker. So the ancillary ones are not going to shift the dial in the claimant's favour. That, as I read it, is what the judge is effectively doing here. So it is a freestanding point. I have promised a short note on fees, which I would do after the course, so within a day or two.
May I just check with my lord whether you wish to lay down a timetable?
Well, we're clearly going to reserve our judgments. It's either Friday or Monday. So Monday would probably be. Is that convenient to you?
I'm sure we can do it by Friday. I don't actually believe it to be very complicated.
Yeah.
Friday.
Friday.
I think it'd be helpful to have it by 4 p.m. on Friday.
Yes. Thank you.
Yes, I can assist the court first.
Nothing else? Thank you, Mr. Brown. Thank you very much. Yes, Mr. Butler.
Just on that, procedural point. Might the appellant have a couple of working days to respond, if appropriate, to that note?
Yes, so that would be 9 o'clock Wednesday morning.
Trying to read the note if possible. Then.
Yes.
Yes, it's not rocket science, is it?
I'm in court tomorrow and Friday, so I'll struggle to agree by the close of Friday, but we will certainly, if we don't have any issue with it, we'll let the court know early next week.
Yes. Mr Brown may be in court as well. So.
Can I deal first, please, with the proper interpretation of the compassionate circumstances policy? Mr Brown says that you, in our case, shouldn't use the Windrush form because you're not in the scheme. You're not in the Windrush scheme. But why then, I would ask, should one use the Appendix FM form? Because we're clearly not in the Appendix FM either. And in fact, we're much further away from me coming within Appendix FM than we are within the Windrush policy.
Well, I think Mr Brown did concede that you could have used the third option.
The set O form.
Yeah.
Yes, but the respondent's notice is predicated on Appendix FM. Now, of course, I appreciate there can be a shift to an extent, but it's not a very promising start for the interpretation of the policy. Could I ask the court, please, to turn up the compassionate circumstances policy, which is the supplementary bundle at page 238. The key words for this court to interpret, in light of my learned friend's argument, are those under the heading applying in the UK for LOTR. What do the words mean? Applicants in the UK must apply on the application form for the route which most closely matches their circumstances and pay the relevant fees and charges. What does that mean? Does that only apply, as my learned friend said, to the immigration rules? Or does it apply, as I would say, to the route, whatever that route that might be, whether by way of concession or by way of rules, that most closely matches their circumstances? And in my respectful submission, as a matter of ordinary interpretation, the answer to that's clear.
Well, I think if you look at it in isolation, there's an argument there, but if you look at the actual Windrush form, it's clear from the guidance in relation to that, in the same way as with Arab, that if you're not within the scheme, you can't apply under that form, and you have to apply by means of some other form, which brings you back full circle.
Well, at the moment, I'm looking just up this document, what's the proper interpretation of this document. And I accept that this document could contain a carve-out in respect of Windrush, as it expressly does in respect of Arab at page 239, but it doesn't. On the face of this form, it indicates to a reader, and one approaches it on the basis of an ordinary, reasonable reader. It indicates that you use the form that most closely matches your circumstances. Yeah. And objectively, the form that most closely matched the appellant's circumstances was the Windrush form.
It appears, we haven't got to this, we may have it online, but I've got it in hard copy in front of me. But it gives the impression that there's a link there. And if you click on the link, presumably somebody can tell us what we would then find. And I think what Mr Brown has submitted is that what you would find is a visa application form. In other words, nothing to do with the sort of thing that Windrush is about.
Well, if that changes the ordinary meaning, then so be it. We haven't, the Secretary of State hasn't sought to put before the court the link, if that's a link, to the certain other documents. So as things stand now, I approach it solely on the basis of what this document says. Now, if that's a link, and whether that link contains a narrow set of forms or a broader set of forms.
Fine, that's a fair point, but picking up what my lady was saying earlier, if as always we have to construe documents as a whole,
yes,
and not taking certain parts in isolation, then isn't it clear from the top of page 239 that if an applicant wishes to be considered for ILR outside the immigration rules, they should apply on form setter?
Well, that for the reasons that I gave in my opening submissions, can't be taken as covering all situations because it goes too far. Because it would exclude Windrush cases. So it would mean that in a Windrush case, you would have to use form SETO. But we know that's not right.
Well, no, that's because you've got a dedicated form that relates to Windrush in the same way as you do for Arup.
So one needs
This
to read
is dealing with, yeah, you have to say that if there is not a dedicated form that covers your circumstances, you use setter.
Yes, so one could read in those words, or one could read in the words that I've read in, which is you use the form that most closely matches your circumstances. It's important to recall that this document is not only contemplating the immigration rules, it is contemplating other concessions covering leave outside the rules. It recognises that those other concessions exist. Mm-hmm. And so when it is talking about other routes at page 238, that is, in my submission, naturally read as covering routes under those concessions too. Because that's what's in the contemplation of this policy. Now, I'd also observe that there is no decision by the Secretary of State in this case. If there's an element of evaluative judgment involved in this question, there is no decision by the Secretary of State that this is a Form FM case, rather than the Windrush case. All you've got, and it's perfectly reasonable for my learned friend to do it, I don't criticise him, but all you've got are counsel submissions. If it's an evaluative judgment case, then one needs a decision from a decision maker, and there is none. I would accept that it's not for the individual to assert on this premise. It's not open to the individual to assert, I'm going to use whichever form I feel like. No. But equally, if that's the case, it's for the Secretary of State to decide, well, there needs to be a Secretary of State decision. And it would be perfectly open to the Secretary of State to say, well, actually, I think that the Windrush form is the appropriate form in this case, because you come sufficiently close to it. There's nothing to the contrary. That's my first point on the construction of the compassionate circumstances policy. There is a factual material which supports my interpretation, because we know from some of the material that was before the judge, and also from the material that the courts considered bene esse, that Danny and Denzel were granted leave pursuant to a Windrush form application, even though they didn't meet the Windrush Scheme criteria. And so the answer to my lady's question, do you have to go back to square one, is actually no, you don't go back to square one and have to make an application on Appendix SETO.
I think Mr Brown's answer to that is it was the Secretary of State who decided to, of her own volition, to exercise the discretion in their case.
But I would respectfully ask the rhetorical question, so what? Mm. It's a discretion conferred by Parliament under Section 3(1)(b) to grant leave outside the rules. It's the same discretion.
Yes.
And indeed, one sees this in the Secretary of State skeleton, paragraph 19.6, and from page 5 of the de bene esse clip. In fact, if I just show the court the clip, this is the unagreed bundle at internal page 5. The question that the head of policy for the Windrush Scheme is asking himself at paragraph 2 on page 5 is this situation in the spirit of the Windrush Scheme? And he is asking that question on the back of a Windrush form application where the criteria for the Windrush Scheme aren't satisfied. Now, whether or not I'm right in my reading of the compassionate circumstances policy, that shows as a matter of fact that the Secretary of State is willing to consider exercising the section 3(1)(b) discretion where a person doesn't meet the Windrush Scheme criteria, if one calls them that, but they've made an application for leave using a Windrush form. That's my second point on this topic. My third point...
The points made in that second paragraph you've taken as to are Windrush-related points. There's no reference to the ADHD or other matters.
And can I well, that naturally leads into the third point that I'm about to make.
Right,
so it's, I think, been submitted that having a close connection to the UK isn't really a Windrush point. Well, there are two problems in my submission with that. First, that the judge's conclusion that the criterion of Route 4 under the Windrush Scheme is a proxy for strong and subsisting ties. And if the judge is right about that, well, strong and subsisting ties are very squarely part of this route under the Windrush Scheme. The second point, which is linked, is if we could look at the Windrush Scheme casework guidance, this additional document my learned friend put in. If we could look within that, please, you'll see the internal page numbers at the bottom of the page. It's page 31 of 54.
What are we on now? Which
Windrush.
bundle?
This is a loose document that my learned friend sent through yesterday.
Oh, I never had that. No.
Ah,
I saw it this morning.
It didn't go in any of the bundles.
it didn't go in the bundles, I'm afraid.
From Mr Brown.
Yes.
No, I'm sorry. Yeah.
Could I, unless my
No,
learned-
if you carry on, I'll
Thank you.
catch up.
So this is called Windrush Scheme Casework Guidance, and it's the long title is Guidance for Decision Makers Considering Cases Under the Windrush Scheme. So it sits underneath the policy document that I showed the court in my opening submissions. And within this, at page 31 of 54, there is a heading, Returning Resident Guidance. Now, I immediately accept that that's not talking about the Windrush Category 4 case that I'm dealing with. It's a different route to leave under the Windrush Scheme. But it is part of the Windrush Scheme. And within what this guidance tells caseworkers is that as part of deciding whether someone is a returning resident, they need to work out the strength of the individual's ties to the UK. And one sees that at page 30, within this section, page 32 of 54. And there's a heading, Strength of Ties to the UK. A person's ties to the UK may be evident in a number of ways. The nature of those ties and the degree of those ties have been maintained during a person's absence will need to be considered when assessing whether a person should be readmitted as a returning resident. Such ties may include, but aren't limited to, family ties, property ties, business ties. And then there's a section on family ties, separate section on property and business ties. And then if one turns forward to page 34 of 54, there's a heading, Strong Ties, which reads, when considering whether a person in the UK has strong ties to you'll want to consider similar factors to returning residents. For example, strength of ties, family ties, property and business ties, and length of residence. However, where the person's in the UK, you needn't consider factors relating to their departure from the UK and their reasons for wanting to return.
So is that a separate category? So what they're saying is that in a returning residence case, which this isn't, here are certain factors, and you use the same factors to decide whether there are strong ties in cases that don't fall within that.
I'm not making the submission that the caseworkers were bound to apply that guidance in our case.
No.
I'm not suggesting that the same result, one would end up with the same result, anything of that kind. My more modest submission is that the concept of strength of ties to the UK is squarely a Windrush concept.
Yes.
And so if one asks the question, is it sensible if someone has a near miss under the Windrush requirements on the basis of the continuous residence element and says, I can show strength of ties to the UK and strength of family ties in other ways, in circumstances where the judge says, after all, that's just a proxy, it makes perfect sense for that issue to be decided by a Windrush decision maker rather than by kicking it off to somebody who makes decisions under the immigration rules, which the claimant comes nowhere near.
Not sure, Mr. Butler, where this submission is heading, because as a matter of law, there is simply the Secretary of State.
Yes.
So when the Immigration Act refers to the residual discretion, Section 3, subsection 1, it's got to be exercised, or at least consideration has to be given to exercising it by an entity known as the Secretary of State. You're not entitled to insist that a particular part of the Home Office must consider your case.
No, I'm not making that submission. What I'm attempting to do is respond to my learned friend's submission that the reason that one should be required to use form Appendix FM or required to use form SETO is because that channels you to the appropriate ear within the Home Office. And the submission I'm making is that my reading of the compassionate circumstances policy makes perfect sense, particularly when, on the facts of this case, using the Windrush application form channels you to the appropriate ear within the Home Office, not Appendix FM or SETO. But I entirely accept the point my Lord makes that as a matter of law, there's a single Secretary of State and all caseworkers are acting on behalf of the Secretary of State. Could I then turn to, court will recall that in my opening submissions on this, I made a point about proper interpretation of the compassionate circumstances policy. I then dealt with the point of principle, and then I dealt with the facts of what, in fact, the decision letter said. So following that structure, I go back to the question, can you better the exercise of discretion? Can you refuse to exercise the statutory discretion by imposing absolute procedural requirements, such as a requirement to use a particular form, such as a requirement to pay a fee? And in my learned friend's submissions, he described the compassionate circumstances policy as occupying the field. And in my submission, the desire of the Secretary of State to occupy the field is understandable for reasons of administrative efficiency and consistency of approach. But in my submission, the Secretary of State can't lawfully occupy the field in relation to the exercise of the residual discretion, the discretion outside the immigration rules, through a policy document or in any other way. And what this case in my submission illustrates, when one looks back to the decision letter, looks back to the Secretary of State's pleadings, and then, albeit in a much more sophisticated way in this court, the essential problem with the that this case illustrates is the tendency by the Secretary of State to treat policy as prescriptive, when in my submission it can't be, unless it is made part of the immigration rules and laid before Parliament. And of course one can posit extreme examples both ways. My learned friend says, well, it would be absurd to allow somebody to write a letter from Afghanistan saying, please can you consider my claim under the Windrush Scheme? Maybe that the answer to an absurd request of that kind would be very short and quick. But equally, one can consider perhaps more realistic situations. So suppose that somebody wanted to apply under the Afghan scheme, but couldn't download the right form, the Arab form, because the internet had gone down in Afghanistan for 2 weeks. But they can write a letter to the Secretary of State, which covers the same material, provides a cogent reason for the exercise of discretion outside the rules. Could the Secretary of State lawfully refuse to consider those representations because they weren't made on the form prescribed by a policy? In my submission, it wouldn't be open to the Secretary of State to do that. That would constitute an unlawful fettering of discretion.
It may not matter, I don't know, but in the course of his submissions, Mr Brown drew an analogy with what happens in courts.
Yes.
And that we laid down certain forms, and he made the point, well, somebody couldn't just circumvent the forms by writing in a letter to us. Do you have an answer to that?
Well, the court's not an administrative decision maker. The court's not the executive, it's the judicial branch, and different considerations apply.
I think the court forms are provided for by statutory instrument. I think that's right. Or the requirement to use a form is in the rules.
Which presumably constitute a statutory instrument made by
Yes,
statute.
they are.
It would usually be the civil procedure rules or similar.
Yes, but they're made by statutory instrument.
Yes. Well, that would meet the problem by that route, because then one will be in the same territory as rules made under immigration rules laid before Parliament. They have the authority of Parliament, and then there's no difficulty at all in having hard-edged requirements. The simple answer to all of this, as Lord Dyson said in the Elvey case, the Secretary of State doesn't like the outcome and wants to have hard-edged rules. It's easy. You either promulgate immigration rules which provide for the use of prescribed forms, or you lay before Parliament an amendment to Section 3, subsection 2, which is what Lord Dyson suggested, to permit the Secretary of State to set broader parameters under the immigration rules, rather than being required to prescribe all rules. So I gave the example of the Afghan scheme. You couldn't rule out a letter if there was a policy which said you have to use a form. If Mr Brown were right in his submission on this point, I would respectfully say that the concession that had been made in the KA case was wrongly made, because that was a case about form. You have to provide biometric data as part of your application form for the form to be considered. And the Secretary of State, as I showed the court, accepted that she couldn't fetter her discretion in that way. And the same applies in respect to fees. I mean, it may be that the answer to my Lord's question is, well, there's statutory authority for the imposition of fees. But let's suppose for a moment there were no statutory authority, and let's suppose there were no Bill of Rights problems with charging fees in the absence of statutory authority. Suppose it's something that could just be done by policy. there'd be no difficulty on this premise in charging fees by policy, but what the Secretary of State wouldn't be entitled to do would be to say, I'm never going to consider an application without the prescribed fee, because that would constitute a fettering of discretion. And the related point is that in my submission, if one is saying to the Secretary of State, please will you consider my case on the footing that I'm almost a category 4 Windrush case. I meet 4 of the 5 criteria. I don't meet the 5th criterion, but I can meet the substance of the rule as it was described by the judge. In my submission, the Secretary of State does need to be willing to consider waiving one of the requirements of the scheme. One is not in that situation cast out into a sea of unprincipled discretion. One is entitled to say, I come very close to meeting this requirement, please will you consider waiving that particular requirement?
What about Mr Brown's point that there's a danger, obviously hard cases make bad law, there's a danger of creating a parallel set of circumstances by means of case law or decisions in the Home Office that would then subvert the scheme altogether, because people could then come in and say, well, look, there was supposed to be, the scheme was only supposed to be for a certain category of people. I'm almost there, but I don't have to do what anybody else who's almost there under the Arab scheme or almost there on some other scheme has to do and apply through the general route. I can apply under the scheme knowing I'm not going to meet the criteria. And I can say, well, you waived your discretion in relation to my cousin or my brother or my auntie.
Well, the principled answer is the Secretary of State is entitled to have hard edges and is entitled not ever to consider near misses under the immigration rules.
Of course.
And there's plenty of case law which says there's no near miss principle in relation to the immigration rules. But in relation to the formulation of policy and guidance for helping to exercise a broader discretion, as I said in my earlier submissions, the Secretary of State is not entitled to impose hard rules, must always be willing to listen. If and insofar as individuals abuse that public law principle and make frivolous, unfounded applications, those can be swiftly disposed of by the Secretary of State.
Why can't the Secretary of State say, well, here is a policy decision, not hard-edged, in the sense that I'm going to shut myself out from considering any other type of case, but if you tick the following 4 boxes, you pass go and you get certain consequences. If you don't tick those boxes, you go into the general pool. And it may well be that you're quite close to ticking one of those boxes and you just missed out on it, in which case that might have repercussions in terms of the overall exercise of the discretion. But if you don't make those 4, then you don't get that extra, if you like, impetus. I think that's the way that the Secretary of State's putting it. I'm putting it very sort of much in the vernacular.
Well, if one adopts that metaphor, if one's cast out into the general pool, one is still entitled to point to relevant factors.
Of course.
And it will be a relevant factor that you satisfy 4 out of the 5 requirements.
Yes.
For falling within one of the paradigm cases in which the Secretary of State will exercise their discretion.
Correct. It's just a question of how you get there.
Yes, and you're entitled to say, and in respect of the 5th, I meet the substance of it. But what the Secretary of State can't do in respect of that is to say, I'm only going to consider that request for exercising my discretion if you make your request on a particular form. But I suppose what the submission I'm making at the moment is that maybe it all just amounts to the same thing. But I'm making the submission that one is entitled to ask the Secretary, one can frame the request as, please waive that requirement. I accept that it amounts to the same thing as treatment is coming within the general pool, but having regard to all of these factors, which amount to exactly the same thing as waiving that one requirement. But I was going to just show the court, if I may, well, perhaps we don't need to turn it up, but what Lord Kerr said in the passage of Lumber that I took the court to earlier. The Secretary of State must be willing to depart from the policy. Now, what in substance the appellant was asking the Secretary of State to do in this case was to depart from that one particular part of the policy. It is not a request from the middle of the sea of discretion. It's a request to depart from a particular provision. And one can draw an analogy with the case of Alvey. So the court will recall that that was about the highly skilled migrant route. Yeah. And the Supreme Court held that the Secretary of State couldn't specify rules through external policy. So you couldn't say in a separate policy document, we're only going to grant people highly migrant status if they come within this jobs list. Well, it was simply no answer to that to say, well, there are other migration routes available. It was no answer to that to say, well, you could make a general request for the exercise of discretion. The problem with it was that you couldn't have hard exclusionary rules formulated through policy. So that was by way of my second point, can you fetter discretion through procedural requirements? And then third, I just wanted to come back to the point I've already made in my opening submissions. What did the Secretary of State actually say in her letter of the 25th of May 2023? She didn't say anything about not exercising her discretion because the wrong form had been used. And the reason in my submission, the letter didn't say we can't consider exercising our discretion because you haven't used form FM, isn't because, as I think my learned friend suggested, there was some infelicity of drafting in that letter. It's because that wasn't the reason. Could I then please turn to the section 31(2)(a) points? And can I deal with the 2021 emails? I think it was suggested that the 2021 emails indicate what would have happened in 2023.
I think it was said that they must be assumed to have been in the knowledge of those making the decisions in 2023, because they were part of the, I called it the clip, part of the file.
Well, if the discretion wasn't exercised, and one's asking the question, is it highly likely that the exercise of the discretion would have been unfavourable to the appellants? I think that's the point at which I was proposing just to touch on this. I've just observed that having said in the skeleton argument that it was unlikely to affect the appeal at all, I now sense that rather more weight is being put on the
No, well, that thought passed through my mind.
2021 emails. And it may be that the submissions I made right at the start of today about the admissibility of that material may have to be considered more carefully. But could I just make this point, that in 2021, the head of policy didn't have before him the submissions that had been made to the decision maker in 2023. And just by way of example, I don't propose to give chapter and verse, could I just ask the court to look in the supplementary bundle at page 78. these, as the court will have seen, there was a first Windrush application which was unsuccessful. There was then a second Windrush application that was made. And if one looks in the caseworker guidance, one sees that that's perfectly permissible. What one's got at page 78 are submissions that were made in support of the second Windrush application. And if one looks within that letter at page 80, sorry, that's the covering letter, then the full letter begins at page 80, same date. And within the letter that begins at page 80, if we look at page 81, at the top of that page, there's an explanation of the client's background, visits to the UK. At the bottom of that page, there's a description of the claimant's, the appellant's siblings. And then at page 93, at the bottom of that page, there's a description of the close family ties that the appellant maintained with those in the UK, even when she was in St Lucia. I don't invite the court to look at this in particular detail. The point I'm making is that there was material about the closeness of the appellant's ties to the UK that was submitted in 2022 and was not before the decision maker in 2021. Still on section 31.2a, if we could just take up the judgment again, please. This is in the core bundle. At page 93. At paragraph 52, second line, where the judge says that there's much material available to the court from which inferences can be drawn. In my submission, he's talking about material relating to the first and second points, rather than material relating to the close family ties point. And the reason I say that is because if one looks forward to paragraph 63 on page 96, the judge notes that the close family ties point, close connection to the UK point, wasn't addressed in the Secretary of State's letter, and nor does the judge point to any other material that addressed this point. That's not an omission on the judge's part. There was no such material. I think the court already has my submissions on paragraph 64 and appendix FM. But just to emphasise that appendix FM is in my submission simply irrelevant to this case because the appellant doesn't come anywhere close to the criteria in appendix FM. Appendix FM isn't some catch-all policy which says if you've got close ties to the UK, or if you've got compassionate circumstances, or if you've got needy children, we might grant you leave under the immigration rules. It contains very clear, hard-edged rules for who will be granted leave. And as one, I wasn't proposing to take the court through it, we've got Appendix FM in the authorities bundle. There are basically two routes. One, if you've got a settled partner in the UK. Two, if you've got a British child. Well, the appellant doesn't have either of those things.
Both her children were born in the UK.
But they're not British, so
Right.
Appendix FM just doesn't help her. She doesn't get close to it.
And by the judge saying, well, these points can be considered under FM, Annex FM, that suggests to me that the judge was saying, and that's all that will be considered under FM, and FM won't meet to consider the Windrush points. But she's one human being. Her life and all the points about Windrush are as much a part of her as what she might say about her children. If the judge had the view that, well, the final 2 points are the same as everyone else who applies under FM, and she's an ordinary FM applicant, she's not. She's not a Windrush neat fit. but she's there in the context of Windrush.
Yes,
That all needs to be looked at,
Exactly.
along with the other factors.
Yes, to take up the language of the head of policy of Windrush back from 2021, her contention was, I'm scared of Windrush.
Yes.
Which the Secretary of State, we know from 2021, is willing to consider under the rubric of the Windrush form, under the rubric of the Windrush policy, albeit not quite fitting into the criteria. But in my submission, to look at Appendix FM is an entire red herring, because the immigration rules, as we know, are hard-edged rules, and they're entitled to be hard-edged rules. If she doesn't come within it, Appendix FM, that's the end of it. Of course, she
Well,
could
not
ask.
quite. There's always exceptional leave outside the rules, isn't there?
Well, so she could ask.
Family life.
She could say, please exercise your residual section 3(1)(b) discretion to grant me leave outside the rules. She could do it on that basis. But that wasn't the basis on which she was doing it. She was asking for the Secretary of State to disapply one of the requirements of the Windrush policy for the reasons that we've discussed. And the court has my submissions. 4 of the 5 elements of category 4 Windrush were satisfied. One of the 5 that wasn't, that element is a proxy for strong and subsisting ties. And the appellant's case was, I've advanced evidence to you, the Secretary of State, to show strong and subsisting ties in other ways. Please exercise your discretion.
Yeah.
That was my reply.
Thank you. Strictly speaking, Mr. Brown, Mr. Butler's replied to your respondent's notice points, and so you may wish to reply in relation to any of those matters. I think that's right, Mr. Butler.
Yes, that's not as I'd understood we'd agree the timetable, but entirely.
No, but I'm not hoping that you've got a reply or expecting you to have one, but I think I ought to offer you the opportunity.
Thank you. That would be opportunistic for me to trouble you for another 30 minutes repeating everything I've already said.
It would be trespassing.
I've been given the authority for fees. I'll put it in writing, but it's 2014 Immigration Act. I don't propose to say anything else unless the court has any questions.
No, nothing. No. Well, we're very grateful to both of you and those behind you for presenting it so clearly to us. We're obviously going to reserve our judgments. We're aware that the 3 individuals at the back of the court feel very keenly about this. We'll do our best to deliver our judgments as soon as we can, but there are important points made in this appeal, and it may take us time. We'll circulate our drafts on the usual basis, inviting you to identify the inevitable typographical errors and other matters, but not to re-argue the case, and we'll hand down remotely, unless there's an application by anyone or a need to do so received by us. Thank you very much.
Thank you very much.
All rise, please.